welcome to The Law Matters once again. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and sometimes your business. We continue to provide information and resources that'll help you to determine whether or not you actually want to handle some issues yourself. If you do need additional professional counsel, the idea is that you'll be better prepared, and so will the professional whom you select. Either way, our goal is to help you save time, money, and achieve the best possible results. Once again, we welcome and thank David Bazar from the Bazar and Associates law firm in East Providence, who continues to offer his insights, information, and input in the various topics that we tackle. And today, our topic is going to be advanced care planning, a wrenching question that patients and families face. What medical treatment's right for me? How do I plan for my long-term care? What do I do with my assets? Of course, a lot of this depends on someone's goals, their values, their preferences, their assets, and those change, of course. And I think that almost everyone would agree that it makes sense that you want to do this while you are able to, before you have, in advance of any kind of health or financial crisis. And people such as attorneys, but not only, are managing these days to give a little guidance to this. So David, as we start this segment, we've talked about living will and some of those, the durable power of attorney for health care. Those are some of the very basic things. Can you just do a quick little recap and then we'll go from there?
Yeah, and actually we should include all of that because part of what we're talking about involves all of the documents we've talked about in the past. So the health care power of attorney, which is the document in which somebody appoints an agent to be able to make medical decisions for them if they're in a position where they're not able to make their own decisions, with some directives in them such as I don't want to be kept alive artificially, don't prolong my life if I'm going to be in a vegetative state, those types of directions. There's also a living will, which is a directive to the medical providers directly of what your wishes are. And then I think probably the most important document would be a very comprehensive power of attorney, a durable power of attorney, which means that it's good even if you, at some point after you sign it, become incapacitated and unable to make decisions, which is one of the reasons you do it in the first place. Another reason would be, of course, if you're just unavailable away and need somebody to help you with things. But a good comprehensive power of attorney can help down the road. And those documents avoid things such as the necessity of a guardianship in probate court, and allow the person who you appoint to help make decisions and plans for you as you age and get beyond your own capacity. Sort of as Larry Barron had said when he was here with us last time, when you're here but you're really no longer helpful. So
I imagine that there are very many different stages at which people may come to you or someone to help them plan for this. Ideally, we said earlier, when you're still of sound mind, able to make those choices. What's the youngest that someone comes in and starts to have that conversation? Just
one of the first times people really start to think about it is when they have children.
Okay.
So that is now something that is of concern to them because how am I going to protect my child? Who's going to care for my child if something happens to me? How am I going to make sure my assets get to my child and that they're protected for my child?
So we started to talk about this just before we went on the air, but who ends up being your client? Suppose you worked for a woman who has a business, she marries, she has this family, she's your client? The husband's your client, the family's your client. How do you work through that, David?
So what we were talking about a little bit is these situations where someone comes in what we broadly might call an elder law type of case. But what is an elder law type of case? People usually think of those in terms of asset protection. And I've heard folks say that, what do I do in that field? Well, I help families protect their life savings against the being robbed by the high expense of debilitating disease, dementia, Alzheimer's, Parkinson's, what have you. And so people come to you in two different stages in those types of cases. It's either a crisis stage where mom or dad is really just about ready to go into a nursing home because of some debilitating disease or age or what have you, or proactive planning where it's, I think at some point in time this may come up as an issue and I want to plan against it as quickly as I can. In either of those cases, on the ethics side, you have to recognize who your client is. And who your client isn't usually is the children. So if the child brings in the mom or the dad, or the children bring in the mom or the dad, you as a lawyer need to let them know up front, well, mom or dad or both are my clients. So I would even take the step, if they came in with them, is to ask them to step out for a minute, speak to my clients, ask them if it's okay with them, because we want the children involved. We're glad they're
Certainly.
there. We don't want them not to be part of it, but we want them to understand that the lawyer's loyalty, so to speak, and his responsibility is to the client, which are the parents. So we get the permission, we bring them in, and we go from there. So that's one of the first steps that you need to do when you enter into deciding what you can do for somebody in this field and help them with that.
Are there any ethical challenges when it comes to the conversation that you'd have with, say, the mother and father, or say it's the father who's likely to have the medical issue, but might there be times when there's a conflict between who needs more protection or how to best protect the man versus the woman versus the couple? How does that work?
Usually, actually, their issues are in alignment. What their goals are the same. And if we're dealing with, say, dad, the husband being the one who's most likely to have a period of institutionalization going into a nursing home, and the mom or the wife is going to be at home, the community spouse, so to speak, you're trying to get the husband or the father in that case the best possible care that you can get him. And you're also trying to protect both of their hard-earned assets that they've acquired during their lifetime, their life savings, the house, retirement accounts, whatever they may have. So generally, they are on the same page, they have the same goals. So usually that's not an issue. It can be, and you have to understand and recognize that when it becomes one. But usually, if a couple comes into you for just an estate plan, trust in estates, whatever their needs are, they're usually acting in concert. And in this particular area where you're trying to protect the family assets, they usually would be exactly on the same page.
And when they begin this, and it's a process, it's not a one and done, it
Right.
evolves as situations and as people age. How do you deal with what might become a situation where there's a declining capacity, or maybe it's a temporary change in capacity and someone says, attorney, sir, I need to change something. How do you deal with that and maintain the integrity of what's intended?
So let's take a hypothetical example. You have a client who's come in and they've done some planning with you. You know what their intent has been right along, and now something has changed. Husband or wife is declining or has declined to the point where they're going to need to be in a nursing home because as hard as, let's say in this case, the wife has worked to keep the husband at home and care for him, it's now a burden on her that she can't bear anymore, even though she wants to. And sometimes it's counseling that spouse as to what they're really capable of doing that's fair to them, and also what's fair to the spouse they're trying to take care of. They just don't have the capacity to do it anymore, or the need is too great for them to be able to do it. So you have to keep in mind the needs of both of the spouses, and generally when one spouse is to the point where they really need to be in a nursing home or some more care than can be given at home, it's as much making sure that that spouse recognizes it if they have the capacity to, as it is for the stay-at-home or community spouse to recognize that he or she, but in our hypothetical, she can't do that anymore.
And you might help guide them through the questions, or even maybe help guide that decision that this
Right.
is no longer viable or whatever.
Absolutely. And I will tell you, we talked about who the client is, and oftentimes the children will come in, And the children want to be part of that discussion because they see mom doing more than she can do. And I've had cases where mom has insisted, nope, I'm going to continue to do this. So we do still try to start putting plans in place so that they can protect their assets. But mom needs to come to that conclusion on her own. And as much as I might agree with the children and counsel mom, this is what you really need to start working towards, she has to get there. And I've had cases where it's taken a little bit of time, but mom has come back to me and said, you were right, I really can't do this. I'm doing a disservice to myself and my husband, and we need to really go and take the next step.
So as you begin to think about long-term planning, most people hear, well, I have some coverage, I have some assets. Almost everyone hears the word Medicare, Medicaid, and of course the strictest is if you are unable, usually it's financially unable. If you're poor, you have
right.
Medicaid. But there's so much planning or so much discussion and debate and controversy associated with the issue about Medicaid planning.
Right.
In and of itself, is that a loaded term? Is Medicaid planning an ethically challenged issue?
Well, I don't like that terminology.
Okay.
Just because it's not the way I look at it.
Okay.
I look at it as a couple has worked their entire lives to save some money, to acquire some assets, to have a fruitful retirement and be able to leave something to their children. That's what they've worked their whole life for, lives. And so I look at it more as family asset protection, or family life savings protection, or whatever you want to call it, but it's protecting what you've worked so hard for your entire life, and as that one person had referred to it before, from being robbed. And it's being robbed by the high expense of that Alzheimer's disease or Parkinson's disease or whatever it is, that now you're not only fighting the disease, but you're fighting to keep enough assets so that the stay-at-home spouse has a life too.
So how might you begin to deal with this? I mean, I immediately think about our need to talk about eligibility requirements and asset transfers, which could get into the weeds
right.
very quickly.
Right.
But in broad brush strokes,
yeah.
take us through this.
Right. So this is something that I have been working hard on getting my arms around so that I can help people with this. But to do it correctly, you have to understand exactly what you said. What are the eligibility requirements? And what we're talking about by requirements, if someone's going to be continuously in a nursing home, hoping to come home, and that's always the goal, you'd like to see someone get better, but you never know. But if there's going to be that cost down the road, and it is a prohibitively expensive cost. The average cost of a nursing home in Rhode Island is probably $9,000 to $10,000 or more, and that's average.
Per week? Per month?
Per month. Per
you
month.
need to say that,
good,
yes.
Good point. So you've got that expense, and at some point in time, if you have spent all of your money and all of your assets in maintaining someone in a nursing home, they could become eligible for Medicaid to pay for their care and stay. And so there are rules about income, there are rules about assets, there are assets that are exempt from being part of what gets paid into Medicaid.
What might those be?
Well, there's a number of them. A prepaid funeral bill, for example,
Okay.
is one. A home is an asset that is exempt because the stay-at-home spouse certainly has a right to have a place to live. And the person who's in the nursing home wants to get home. That's always the intent. So they would have to have a home to get to if they got better and could do that. So
A car?
you can have a car.
One.
Yes, right. So what I do when someone comes in to see me is we have to understand at what point in the process they're at. And that's what I talked about, the difference between proactive planning, I'm not really close to having to go to a nursing home, versus crisis planning. What can I do now that it's around the corner and I haven't done enough of anything to plan for that. And there are things that we can do. And I've had clients come in worried about the home, worried about all their assets, and worried about having enough income to be able to stay at home while the other spouse is in a nursing home. And in some of those cases, I've been able to save not only all their assets, but also some of the income that the spouse would have who's in the nursing home, which would otherwise have to go to pay for the nursing home. So there are techniques that we can do. And my advice is the sooner you go speak to an attorney about it, the better off you are, because the more time you have to plan and to get things in place, the better off you are. But real proactive planning is something that requires a lot of time, and people will talk about the five-year
look back.
5-year look back period, and that's something that has to be factored into proactive planning.
So proactive planning, let's not say 5 years. It could be 10, it could be 20, it could be more than that. And so when you begin those, say you've had that 20-year window or 10-year window, what kinds of things do you do? How do you approach it? And obviously it depends on every individual case and preference and value and the rest. But
So every case is different. And especially in proactive planning, there's a lot of different factors that would have to go into that. How old are the other folks? How is their health? And what kind of assets do they have? And what, most importantly, when someone comes in to speak to me about estate planning in general, whether it's because they're concerned about protecting family assets from a debilitating disease or from creditors, or someone told a story about a client they had whose daughter was getting married, and the poor father kept putting his hands in his head and said, "My daughter's marrying an idiot." And so his concern was getting money to his daughter when he died, but protecting it from his idiot son-in-law. So whatever the goal or the driving issue is, as a lawyer, I like to sit down with my clients and listen to them and go through what their issues and concerns are and what are their goals. And then once we determine their age, their health, their assets, their goals, we can prioritize. Do we want to protect the assets from a debilitating disease or from the idiot son-in-law?
Okay, let's go with the idiot son-in-law, because I'm sure you piqued interest there.
Okay. So we have and that case in particular involved someone who the financial planner had brought to the lawyer, and the issue was, in his mind, how does he save a huge $20 million tax liability at his death, because there was a lot of money. And so the lawyer went through the form and said, well, look, my daughter's getting married, exclamation point, exclamation point, exclamation point. So the lawyer said, do you mind if I ask you about your daughter's future wedding, because I see there's a lot of exclamation points. And the financial advisor said, don't bother him with that. We need to move on to the important things. And the client said, no, I want to talk about that. And so then he started talking about that. And the client was actually in New York, and the lawyer and the financial planner were in Florida. So they're on the phone with him. So he tells the story to the lawyer, and the lawyer says, if I have a way of helping you devise an estate plan that protects the money from your idiot son-in-law, would you be interested in that? And he said, and the financial planner says, stop talking about that. And the client said, shut up. And see, the financial planner says, I told you he didn't want to talk about that. And the client says, no, I'm talking to you. How soon can you get here? And the lawyer said, how soon can you send me a retainer and a plane ticket? I'll be right there. So you need to know what it is that is your client's interest. And in that particular case, it's really what we would normally use as a living revocable trust, where the client's putting money into a trust. And the trust can do a lot of different things. It can do some tax planning in that trust for that guy who needs all that money protected in tax planning. But then the revocable trust becomes irrevocable on his death, and the trust holds the money for the daughter. And as it holds the money for her, she can be the trustee and the beneficiary, but only of the income distributions. If she wants to get to principal, there has to be an independent trustee who says, yep, that's a good plan, or no, you shouldn't use the money for that.
And you would help with even finding the independent person who would do that?
Frankly, it depends on the family and the family situation. Many times a sibling can be the independent trustee. Sometimes you might want a bank or a financial planner or some accountant or some other person to be the independent trustee.
Could the lawyer be one?
Not if I'm drafting it. I don't recommend that because that puts me in a difficult and potential conflict of interest position with the client, which would become the daughter. So I wouldn't recommend doing that.
Yes.
But certainly if there's a trusted accountant or a sibling, because independent trustee doesn't mean that it's a professional paid trustee. It means it's someone who doesn't get the assets that are in the trust. So that trust that became the daughter's trust she's the beneficiary, and even a sibling who wouldn't be a beneficiary is then considered an independent trustee.
Good answer.
Yep.
So some people have things in wills, but also this, if someone, especially if they have a lot of money, but not just if they have a lot of money, an estate plan and retitling some of the assets. Talk about that a little bit, if you will.
For any plan to work, especially if it involves a trust, and the folks that come in will give you their goals, and one of the goals oftentimes is avoid probate, and of course a trust is a good asset to avoid probate, protect the assets from you know who, the son-in-law, or creditors, or divorce, or whatever it might be.
Yes.
And so in order for that trust to work, the assets to avoid probate have to be in the trust. If they're not in the trust, then it goes through probate. The will, of course, if it's designed correctly, pours everything back into the trust, but you haven't accomplished the goal of avoiding probate if you haven't retitled the assets into the trust.
And if something is in an estate, then that counts as not an asset that the state, whatever its Medicaid qualifications are, it's no longer one of the things that they are looking at.
So when somebody dies that has been in a nursing home, the estate recovery unit of Medicaid will say, has there been a probate? And if there has been a probate, whatever goes through probate has to come back to pay us whatever we paid as a creditor of the estate. So again, if a plan is being made to protect assets from being used for a nursing home or paying Medicaid back, the plan has to be crafted so that assets don't end up back in the estate if the person's qualified for Medicaid. So oftentimes, I've had a plan that I've been working on for a client where the wife has to go into the nursing home, and he has assets that are his as the community stay-at-home spouse. And if he dies before she does, he doesn't want those assets to go back to the spouse because that'll knock her off of Medicaid and no longer be eligible for the payments that are being made on her behalf. So in his will, he's actually created a special needs trust for the wife. And what that does is it allows the money to be used for care for her that wouldn't otherwise be covered by the governmental benefits that she gets. And at the end of the day, if there are any assets left in that trust, then those assets would go back to the state.
I guess it's important to note that every state has its own different requirements, and I understand that some are more conservative than others when it comes to that estate recovery. In other words, some may more aggressively go after it. I guess, does it need to be said that always Medicaid is supposed to be the payer of last resort, use everybody's everything, come to us last? So if they're in that position, doesn't it make sense that if there was a plan in place, there really wouldn't be all that much that they would need to tap into or have to tap into?
If the plan is created correctly, that's true. Now, not only is it state by state for asset recoveries, as you talked about, because some states will have enhanced asset or estate recovery, which is not just what's in probate, but what was potentially in that person's name, a life estate on a deed they might go back after, and things of that nature. So state by state, not only do they have that, but they also have different eligibility requirements slightly. Medicaid is a federal program, but each state administers its own Medicaid dollars in a program. So for instance, in California, you have heard of that half a loaf thing that was taken away with by most states with the Deficit Reduction Act back in '06 or '05 or whenever that was.
Explain that.
So it used to be that they didn't count the period of ineligibility until they counted it when you gave money away. And if you didn't go into a nursing home for a period of time, then that period had already started to count and you could give money away and be safe. And they did away with that. They don't count the ineligibility period into your otherwise eligible for Medicaid, which is when you're already in the nursing home. So now you have to be paying for that period of time that you're ineligible. And what happened is in California, they still administer it the old way. In California, they have many different rules than other states, which are much more generous and liberal to the person who's getting Medicaid and the family that would be otherwise paying for it.
We often say that there are times when people can do it yourself. It certainly makes sense that someone could call and find out what their state Medicaid eligibility requirements are, but on the other side of it, in order to comply with those and do it rationally and appropriately, it sounds like that part of it is definitely not a do-it-yourself option.
This is not a do-it-yourself field. Not only is it not a do-it-yourself field, there are very few of us lawyers who have studied and understand the rules and understand how you have to apply the rules. So not even every lawyer can do this.
So help us make a decision. What questions should we ask a potential lawyer about his or her qualifications? What are the key questions to ask?
Well, is this an area that you practice in?
As defined by?
Do you create family protection trusts? Do you know what goes into an application when someone applies for Medicaid? Can you do the application if it has to be done? Do you know all the rules that Medicaid looks at for transfers, eligibility, countable assets, non-countable assets, income requirements, all of those things?
So someone should ask those questions.
Yeah.
Now, when we talk about someone going into a nursing home, I think it needs to be said at times that not all facilities will accept Medicaid.
Right.
They'll accept Medicare, private pay.
Right.
But if you care about who your loved one being in the best possible place, do you not want to ask or think about what those facilities are, who has what requirements and what they're willing to accept? And part two of this question quickly, David, is if you are private pay and Medicare and special coverage and then it runs out, are they required to keep you there when you've spent down?
Yeah, so those are two really good questions and very lengthy, so I'll give you a quick one. When we meet with clients, one of the first things we need to know is that they understand the difference between a facility that has Medicaid beds and one that doesn't, and where do they want their loved one to be, and they need to understand all of that goes into that. Because if you're in a facility that doesn't have a Medicaid bed, there is an eviction process. That's the second part of the question. It's very difficult and lengthy and becomes a very big problem really for everybody involved. So you should be able to understand all of those rules before you make a decision as to where you want your loved one to be.
And you actually talk with people and ask them each one of these questions, because I asked this of you. Not everyone necessarily would have that as a question. They just know that there's a plethora of
We raise
homes
that. When someone comes to us, that's part of what are the goals, because we want them to understand when they're deciding what their options are, when they decide how to implement their goals, that these decisions will impact where someone can be. So check out where you want someone to be and understand what the rules are before you get to the position where they have to go in.
Good to know. We've covered plenty about this topic. We hope that it's been helpful to you, and we hope that you will stay tuned to Law Matters because it matters to you.